Hello, everyone.
How are you?
I'm good. Sorry for the late entry in here.
All good. I'm going to be driving in a minute, so I'm going to turn off my video.
Well, it's not on anyway, so we're already.
Okay. That's been my day.
Nobody's video is on. I see how you people are. Well, got to see Weston. That's all that matters. Weston's smiling face.
Do what I
can. All right, let me get one more minute for people jumping in. I see that the listing agreement's not quite as popular as the rest of the contracts, but that's okay. All right.
Hey guys, hope everybody's having a good day. I'm in a car wash right now. I thought I'd make it home in time, but do you hear it?
Well, there we are. That's all right. Let's see if I got everything I need. All right, I need some access. Give me one more second. Get this screen share set up.
You're literally the neediest person I've ever met.
I try.
I'm just kidding. Let me get it to you. And I'm going to text you the secret passcode so you can just grab it anytime in the future.
Anytime I can do that, that's a lot of power.
I know. Only for you. That's why I can't say it here.
I know. 1, 2, 3, 4, 5.
Yeah, and only 2 with their cameras on. So
right? Yeah.
You're going to have an exciting contracts class today. Okay, bye.
Bye. All right, so let's get started in here. Hopefully you guys will see the infamous exclusive right to sell listing agreement. Give me a thumbs up if that's what you see, Weston and Mike. All right, good. So you guys are gonna be my guinea pigs. All right, so what we're gonna do is we're gonna dive into more seller side contracts as we get into this. But since we're still in the first round of the contract series, we're just gonna go through the listing agreement. What this is gonna also allow us to do is open up some discussions on areas in which we are seeing debate and how to handle different things. We're also going to have an opportunity to chat a little bit about the clear cooperation policy, which everyone loves. So we're going to jump into that. I do apologize for those of you that showed up last week. That was a miscommunication on my part. That was one standing meeting I had that I could not move, but we will continue to have these Tuesdays at 2. All right, so this is the exclusive right to sell listing agreement. This is the agreement you would use in listing any property that you are going to be advertising for sale. Now, understand that in order to do any sort of advertising legally as a South Carolina licensed real estate agent, you have to have this agreement signed. So if you're going to have a listing going on the market and you want to share it in the market center or anything like that, you technically have to have this listing agreement signed. You cannot advertise someone's home without that. Now, we had a discussion earlier today with someone in my office who said, hey, I've got someone who has a potential listing they know of coming on the market. They told me about that. Is there anything wrong with that? There isn't for the agent who heard the news, technically. However, the agent that shared the news, just understand that if you're sharing or advertising a listing, you need to have a listing agreement. In order to do so. All right, so let's jump through this. So the first part of it is pretty basic, right? You're gonna have all the information on the property. You wanna have as much information in here as possible. As always, you wanna look at any situation with a contract as what happens or how to be prepared for if something goes wrong. So you wanna avoid as many blanks as possible. You wanna fill out all of the information that is in here. And if you don't have it, you at least dash through it so we can't fill anything in. Obviously, no one's probably going to do that. However, it's important to have all the information in there. The listing agreement is between the owner. You want to make sure it's the owner of record. A couple situations that you might want to be aware of. You're listing a property that was purchased by a spouse or significant other or partner who has since gotten married or joined in ownership to that property since they're now selling. Want to make sure that you have clear understanding of who's on the deed, what their names are. If it's still their maiden name, it needs to be written on here exactly as it is on the deed. Now, this is really more important for negotiations of the contract. However, go ahead and start it early on in order to get ahead of the game so you're used to putting that number or that name on there. As far as how they would sign, so for instance, we have a seller right now who, when they purchased the property, they were not married. So the property was put in the wife's maiden name. They've since gotten married. She now has everything on the contract, still is in her maiden name, but signs it as she would sign anything now. Most of that is taken care of at closing with the alias signature page. Couple things on the time frame. Listing time beginning on X. Now, here's where some confusion lies with the new Clear Cooperation. You want this time frame beginning at any time you are going to start talking about the listing. Now, if you're going to start talking about it internally in the office, then obviously you would want to put today, September 8th, as the day that those begins the listing. So when you show up tomorrow, you can start telling me about it with no pressure to put it in the MLS. There is no deadline anymore from when the listing date is to when you have to have it in the MLS. That was a change that was made back earlier this year, which a lot of people don't understand, is that with the Clear Cooperation, hold on. Oh, it is recording. Okay, good. I needed to make sure. With the Clear Cooperation policy, one of the things that the local MLS did is they basically changed the rule to say that there's no deadline for you to put the listing into the MLS as it relates to the date on this agreement here. That deadline is only tied, the deadline to go in the MLS is only tied to when you publicly market the listing, which we'll come back to in more detail. So just keep that in mind. If you're 2 weeks out and your seller is still going to be getting things done to the house and you still want to make sure you lock up the listing agreement, you can post date it if you want, or you can go ahead and put today's date in there. It really does not matter, to be honest with you.
Garrett, I'm sorry, I know you're on a roll, but I thought it was 2 days where you get a $250 fine.
No, so it was 2 days prior to the Clear Cooperation. It's no longer 2 days.
Okay.
Yeah, and the fine on that was not $250. I think the fine was less. Doesn't matter now anyway. It doesn't apply to that.
Yeah. Okay.
Now the fine will come in as if you put it in, if you do publicly market it and then you don't have it in the MLS within 1 day. But again, we'll come back to that. Now, another thing for the ending date on your listing period, one of the things that I've seen people do, and we did years ago, just from a practice standpoint that makes things a lot easier, is we only have 2 expiration dates in our business for listings, and that's the end of June and the end of December. The reason that we did that is because I was tired of having to wake up at the last day of every month to say what expires today. So now I know that I only personally with my business have to check expiration dates twice a year, the end of June and the end of December. Never had anyone push back on that. If I were to list a home now, honestly, I would put it to, well, in this market, I'd be fine. In September, I'd put it to the end of June. After the first of the year, I'd put it to the end of the year. Always have an easy exit clause you can put in there. Again, the purpose of this is to think scalability. It's easy to manage 1, 2, 3 listings. When you get to the point, if you're wanting to take 10, 15, 20 listings, again, would possibly be a challenge in this market, but what you don't want to add to your list of things to do is tracking expiration dates. And that way you always know there's only twice a year you have to check on your expiration date. I didn't come up with this because I had some brilliant epiphany. I came up with this because I was tired of getting phone calls from sellers saying, hey, why the heck am I getting calls today? Because I was rounding the expiration date off as evenly 90 days from now. So today I do it, okay, great, it ends on December 8th or whatever it may be. Stop doing that. Do it to the end of the month. If they push back on the time frame, cross that bridge when you get to it. Rarely will that happen. All right, so I'm going to make sure I post. We got one question in here really quickly. Let me see what we got. Good to know. Okay, yeah. So again, it's just a practice. I've heard lost audio. Can everybody, Weston, can you hear me? Okay. So paragraph 1. So this is where you are doing the consent to dual agency or designated agency. This is also where they acknowledge that you have explained the agency relationship with them. So if obviously the first paragraph here that they're initialing is going to be that says you've explained the different agency relationships with them. And then they're going to say permission to act as a dual agent will not be considered, or it may be considered. I would always encourage your clients to put may be considered on both, especially designated. Now the question that comes up is, when will these be used? The only time that I'm really going to say absolutely use dual agency is if they are actually two clients of yours. If you had a listing and you had a buyer with whom you're already working that wants to put an offer in on it, or if you happen to put on in the unlikely chance that, you know, the couple listings I have per year that you put an offer in on, that would be a dual agency. Everything else will be worked as designated agency if it's with any Keller Williams person in Charleston, because they are under the same broker in charge. The only other time that you will use dual agency is if you are on a team. So if you have a team and you're the buyer's agent on a team and you put an offer in on one of your team's listing, that also will need to be disclosed as dual agency. The paragraph 2 talks about the terms of the agreement. So this is the pretty easy part. Here's where you're putting the listing price as well as the commission that is going to be put in here. Now, I get this a lot. People sign a listing agreement, not sure what the price is going to be until we put it on the market. So they fill out a listing agreement, they submit it, they start advertising, but don't have the purchase price yet. That is not a valid listing agreement. A valid listing agreement has to have a price in the contract. It cannot be TBD. It cannot be blank. It has to be a price. Now, if you have a situation where there is maybe an understanding that between now and when the house goes on the market of, you know, we want to list it at 375, but if this one home sells and we can push it up a little bit, we might want to go to 380. You can always change this down the road and you can have that discussion with your seller. But in order to have a valid listing agreement, you do have to have the price in there. There was a discussion, there's a question in there about dual agency. No, dual agency is allowed. It would have to be in a situation where either I'm the listing agent on there, or if you have a client. Now, if you do not have a client that is both a buyer client and a seller client that is represented, it's not dual agency. You would just represent one and you have the other person as the transaction broker. But if you have an actual listing client and then you had a buyer client that is interested in putting an offer in on the property, then that would be dual agency. All right, so now let's go back to the rest of this. They've changed this listing agreement. They changed it earlier this year, and one of the changes they made is where you're putting in the commission. This used to have a total commission as well as what commission is split at this point, which was a little confusing. So they've removed that and put it into a different part of the contract. So this is the part of the contract where you will actually put in the percentage, whoops, I didn't mean to highlight that, the percentage of what the listing is going to be if you're doing a percentage, or a flat fee if you're putting this in there. So obviously, again, any discussion of, well, we're all almost the same brokers, this is where you would put whatever you've negotiated to. Typically, what we're seeing a lot and what a lot of people are negotiating for is 6%, knowing that they'll be offering out 3% to the other side. We do not have written standards from a commission of what you have to take. However, if you are going to take less than 6%, you cannot keep more than you're offering out. So if you're going to go to 5%, don't try to offer out 2 and keep 3. We're not quite in that market yet. That's a KW thing. If you have some questions about that, we can talk about that on the side. But just because the seller out negotiated you doesn't mean that you should punish the buyer's agent on that. So if you have to go to 5 at a minimum, do 2.5, 2.5, or 3 and you take 2, depending on how you do it. So that's where you would put this in here. The rest of it talks about when the fee is earned, which is basically when you have a purchase option or exchange or a lease. If you were doing leasing, which most people are not doing, if you're doing a marketing of a rental, it would apply to that. Basically says as long as that all happens, then you've earned your commission. It also says that you agree to defer your commission until the closing date or extension thereof. So if you obviously had original closing date of September 30th, it gets pushed, you can't say, well, I need my money today. Now, you technically could go after your money if the seller completely bails on the contract. Let's cross that bridge when we get to it and ask me, and then we'll go from there. In the event that you do get out of contract with the owner, you will put in here a protection period of how many days after the expiration or when the agreement is terminated that the buyer, if they sell a property to a buyer who the property was shown by the owner broker, another broker, or another person or the firm during the term of this listing agreement, then the broker's full fee shall be payable to the owner. Okay, so if this only covers if it were shown during the term of the listing agreement. This also is a little bit different, where this used to be just a protection period, where if anybody bought it within a certain period of time, that you would be protected from there. This protection periods, by the way, a lot of people put 30 days in here. This protection period will be terminated if the owner enters into a listing agreement by another broker during the protection period. Okay, so if Weston has a listing, he's trying to sell my property and it expires, he didn't sell it, and then a buyer that came in and showed it while it was listed with me comes in 2 weeks later and he hasn't relisted, or I haven't relisted, then I owe him the commission. If I relist it with someone else, another broker, then obviously that protection period is not covered. See how we're doing with our, all right, good. All right, page 2 of the listing agreement. Again, for the purpose of this agreement, basically what it's saying is this should be any transfer, legal, equity, or beneficial interest in the subject property. It's basically saying in order for this to be executed and for me to earn my commission, it has to be, you basically have to transfer ownership into it or give equity interest in it, which would also be relayed to if you were doing it as a rental. Compensation to other brokerages. This is pretty interesting because there has been some misunderstandings of what to offer to whom. Again, I'm not in the business of telling you how you should run your business. That's not what I want my job to be as a broker. However, I'm going to encourage you to do things that will give your sellers the highest and best exposure to their home. So the compensation to other brokerages. So the first one would be, what percentage are you paying to the buyer's agent? And this would be, if you listed at 6, you would put 3% in here, or if you have another, percentage that you're offering out. If you do not have, if you're only doing a percentage, dash out this line right here where you, instead of putting a flat fee. Transaction brokerage, which is non-agency. This is not sub-agency. Sub-agency actually does not exist anymore in South Carolina. So the next revision of this agreement should get rid of sub-agency. Transaction brokerage, in my opinion, should be offered. If you're a transaction broker, you should be offering them, actually not if you're a transaction broker, if you're the listing broker, in my opinion, you should be offering the transaction broker just as much as you're offering the buyer agent. There is no reason, there's no higher risk to you for them having a transaction broker versus a buyer's agent. The last thing you want to do is discourage in any way, and I'm not saying that not making the same amount of money would discourage them, but it might. You want to make sure that if you're offering out 3% to the buyer's agent, that you should also offer out 3% to the transaction broker. This was confused because when it first came out, a lot of people were hesitant to do it because of the fear of what sort of risk opens up by allowing transaction brokerages or transaction brokers to bring a buyer. I don't see personally where there's a risk there, and I want as many people to see the listing as possible. The reason that sub-agency doesn't exist anymore is because transaction brokerage was created. Transaction brokerage, like it or not, is the default relationship between an unrepresented buyer client and the agent involved. Okay, so just keep that in mind. So if I'm the listing agent, Weston comes in to buy the property and he doesn't have an agent, then technically I'm a transaction broker to him in there because he's unrepresented. And I should have him sign a transaction brokerage agreement, but even if he doesn't agree to do so, that's where he defaults as it relates to the agency relationship in South Carolina. Now, I'm going to open up a can of worms here because it's a great time to do it, because this is happening quite a bit. In the event you offer out a percentage here to a buyer's agent that is less than what they've contractually had their buyer agree to pay them, then you might run the risk of that buyer costing your listing costing more money to that buyer because they have to make up the difference. Let me explain what that means. So let's say I only offer out 2.5% to a buyer's agent, and Weston comes in, and I'm picking on Weston because he's the first one on here. Sorry, Weston. And you have your camera on, which you're probably now not going to bring your camera. So let's see who I'll find someone else next time. Anyway. No, don't do that. So let's say Weston has the buyer's agency agreement, and in that buyer's agency agreement, he has had the buyer select where he will get it paid at least 3% out of the transaction. Well, if he has that in his buyer agency agreement and I'm offering out 2.5%, there's a risk that if the buyer wants to buy my listing, it's going to cost them more money because they will be responsible for the additional 0.5%. I bring that up for two reasons. Number one, if you're going to offer out less than 3%, know that you have a risk of buyer's agents that do have that agreement where they'll get paid at least 3%. Number two, if a buyer's agent calls you and says, hey, Joseph, I notice you're offering out 2.5%. Will you be willing to pay 3% because my buyer has agreed to pay me 3% and I just need to make sure that they understand fully what they're getting into from a financial standpoint before they make an offer? That aggravates a lot of listing agents. And I get the phone call that says, I can't believe this agent did that. They're telling me that they're not going to sell the property if it's not 3%. That's not what they're telling you. Some of them maybe, but for the most part, what they're telling you is, no, I have an agreement with my buyer where they will cover the difference. So it may cost them more money to purchase your home than the property next door that's the exact same price, but offering a better commission. So again, it's not happening often. However, it's happening. And you just need to be able to do two things. One, explain that to your seller, should you get an agent that reaches out to you. And then number two, from a buyer's agent standpoint, if you have that in your buyer's agency agreement, there is nothing wrong with that. Legally, ethically, everything is fine. Just know that you may put your buyer in a position where they have to make a decision on whether or not they want to buy a house based on whether or not it's going to cost them more money out of pocket. And then you have to be willing to you have to make the decision whether or not you want to take that all the way to fruition. I know a lot of times buyer's agents may not do that, but you would be surprised how many listing agents will then offer out the 3% should you approach it from that standpoint. All right, earnest money. This is going to be a quick one because earnest money paragraph and all the contracts in South Carolina say the same thing, that the escrow agent will hold earnest money. The earnest money is a promise to buy the property, and if they default on it, then the earnest money will go to the other party as long as, in big bold print here, they have a distribution agreement or they've been directed by a court. So black and white, it can be as plain as simple or plain as can be that they defaulted on the contract, but Mr. and Mrs. Seller understand that at the end of the day, it may not be as simple as you think. We still have to have an agreement by everyone. All right, so really quickly, so Penny asks, can you change your buyer's agreement? Yes. In what regard though? Like if you had the guarantee for 3%, could you then go back and say, you know what, I'll take 5? Or excuse me, 2.5? Yes, you can do that. You can make that decision at any time.
Okay.
Now, and again, there's not to get bogged down in the details, but it's a great point. A lot of buyer's agents may use this as a strategy because there are some listing agents out there that are only offering 2.5%.
Mm-hmm.
So they're going to do this 3%, approach the listing agent with it. And the listing agent may say, you know what? Yes, I'll pay the 3%. If they say no, you can always make the decision at that point to say, you know what, Mr. Buyer, I'll go with the 2.5% more.
Right.
It's totally up to you.
Joseph.
Yes.
So on that, starting in North Carolina, I always put on my buyer's agency % agreed to an MLS listing instead of putting a number. And I do that here. Is that right or wrong?
You don't need to add that here. It's covered in the, I don't have it in front of me of what section it is, but it's covered in there that you will take whatever the listing agent, whatever has been agreed upon by you and the listing agent.
Right, but in my buyer's agency, do I need to put something in there for 3%, 2.5%? I never put a number in there. That's what I always put there.
No, you can, and again, we can come back to this because it's the buyer agency side, but there are 3 different options, maybe 4. The 2 that we're talking about, one says I'll get paid whatever I agree to get from the listing agent. The other one says I'll get paid at least this, and if I don't get paid it, then you'll come up with the difference.
Okay, and then, but if we do have 3% in there, I mean, if we did that and it was 2.5, we don't need to go back and amend that, do we?
If you change your agreement technically yes, but if you've decided with the buyer, hey, you know what, they're offering out 2.5. If I'm the buyer, I'd want to amend it because the agreement's saying I'm going to owe you the 0.5%. But if I know you and trust you, I'm not going to worry about striking that.
Okay. All right. Okay. Thank you.
Yep. All right. So let's go to paragraph 5, signs. Owner grants the broker exclusive right to display for sale, under contract, sale pending, or similar signs on the property. So you can put those signs on the property. You understand that. 6 and 7 talk about your duty as a broker of what you're going to do. One of the couple things that are covered in here, without boring you with line by line, it does say that the owner understands that you're making no representation or guarantee of the sale of the property. That being said, be careful on how hot you're telling people the market is, because we're still seeing some listings that are coming on that may not be getting the contracts or multiple offers, but are still selling in a good period of time, in a decent period of time. The second part is talking about the broker liability limitation. I am going to go through this a little bit more because this does talk about a liability. I'm not saying you need to explain this line by line when you talk to your seller, but you do want to understand this. And basically what it says is that the owner agrees that you've provided them with benefits, services, assistance in bringing about the contract that comes with the listing agreement. In consideration of the contract that comes with this, compensation, benefits, and all of those things, the owner agrees that they shall pay broker's attorney fees and that the broker shall not be liable to the owner in the amount exceeding the broker's compensation. The reason I bring this up is this basically is saying that the broker can only be held liable to a certain amount if the owner misrepresents something as it relates to any sort of, if you represent a seller and in the future it comes up that there were termites and for whatever reason nobody found there were termites. It's a terrible example, but let's just say that's the example. This basically says that you're limited on how much you can be held liable for that it'll all fall on the owner. The reason I bring this up is we have recently had a seller that has looked at this and said, I don't want to sign this. I don't want this paragraph to be in there because I don't know. I'm representing that I don't know something about the house, but I don't want to be held liable for your costs and risk as well by simply saying I don't know, and then they try to come back and prove me wrong. If that happens, I don't know that that would be the hill I would die on and say no to it if the seller wants that struck. Just recently, within the last 2 weeks, had an attorney look at that and say, you know what, if they strike that, quite honestly, they're still going to come after you anyway. Or everybody, you can't stop a seller from, or excuse me, a buyer from going after the seller. So it's really not a huge deal. All right, owner's duties. This would be a good opportunity to use this as a script. Mr. and Mrs. Seller, here's kind of what you're agreeing to. You're gonna give me reliable information. If anyone outside of who comes directly to me inquires on the property, you're gonna put them in touch with me. You're gonna allow the property to be inspected and shown by the buyer's broker, the agents, buyer's agents, and cooperate in scheduling and carrying out such showings and inspections as necessary. Now, question that comes up on this is what about tenants? The tenants don't want to show the property any more than they have to. Here's where you have to be careful. You are not party to the lease, so don't try to be the police of the lease. So if you've got a seller or a listing that's on the market and you've got a difficult tenant in there, it's not your job to convince the tenant that they're wrong. It's the seller's job. Don't take that on yourself, because then you get into the gray area of interpreting their lease and everything that comes from there. So if you've got a seller, or excuse me, a tenant that says, well, we've already shown it once and they've already had an inspection, we don't want to come back in, but they have to do a final inspection or whatever it may be, then it's going to be up to the seller to get you back in the property. And the seller more than likely is protected by the lease that allows them to get into the property with substantial or appropriate notice. You're going to offer the sale of property to prospective buyers. You're not going to discriminate. You're also going to permit me as your broker to take on any reasonable costs and repairs that will not exceed blank, and that you'll reimburse me. Most agents are putting 0 here. There are a couple agents that are putting in a marketing fee that would say, hey, you're going to reimburse me of an additional fee of this. That's completely up to you whether or not you want to do so. If you are going to charge an additional marketing fee or anything that's not on the listing agreement, the only thing that I require is that I review and approve that paperwork. I know some people have a flat fee that they charge in addition to the fee that's on here. Again, legally, ethically, all fine as long as it's disclosed. I just need to see the paperwork to make sure I'm familiar with it. They're also going to allow the attorney to pay my commission at closing, as well as the commission that's going to be paid, that's going to be split with the buyer's agent. And then you're going to give me permission to publish all sales data into the MLS. I'm going to be able to take photographs. I'm going to convey marketable title. meaning that there are no liens on the property that cannot be cleared at closing. There are no civil suits against the property or anything like that. They're going to allow people to the settlement statement to be distributed to everyone. They're not going to deal directly with prospective buyers during the agency. Again, these are good things to highlight, by the way, not in a way to say, here are the rules. Use them as an outline. So for instance, this one in the beginning, Mr. and Mrs. Seller, one of the things that may happen is you may have people that come knock on the door. You may have people that hear of it through a neighbor or a friend. They gave you the number directly. When that happens, be sure to pass that information to me so I can make sure that you're properly represented in here and we're not disclosing any information that we should. It's the same script you would use for this one. You're not, in the event you have any prospective buyers, or if we go under contract, in the event a buyer comes and tries to ask you any questions directly, bring me in on that so I can help make sure that I, protect you in that and that you're shielded on any of those. This doesn't have to be a rule of what not to do as much as why you're going to step in and protect them. Also going to allow them to divulge the existence of offers on the property, and then to furnish them with any written instructions regarding any confidentiality of information upon termination or completion of this agreement. Which basically means, by the way, if this doesn't work out, Mr. and Mrs. Seller, if there's anything you don't want me to disclose on here, like what the listing price was or whatever's in this contract, you just need to let me know that in writing. All right, so that's their duty to you. Questions so far? Everybody looks so excited. I like that I'm seeing more smiling faces, by the way. West instead of trend. All right, property information or seller's property disclosure statement. What this lengthy paragraph 9 says here, and this is what basically you do need to spend some time on this, but here's how I'd summarize it. Mr. and Mrs. Seller, what this paragraph says here is when I send you the property condition disclosure statement, you're going to go through a handful of questions that are going to basically ask you if you know of any defects that are on your home. You have one of 3 answers. Yes, there is. No, there isn't. Or I do not know. It is not your obligation to go find out the answer. However, it is your obligation to answer them honestly. So when you fill that out, answer them as honestly as possible. This is a disclosure, right? So if something does come, end up being false or left anything out or misleading, this is basically just saying that you've read this and you know that I've told you that basically you're only disclosing what you know. And in the event something comes up and finds out from whatever issue that it should have been known, that you're not going to hold me liable for it, or that you're not going to hold me liable if you refuse to disclose anything that you know about. Basically, be honest on the property disclosure and everything will be okay. That's how I would explain that one. 10, disclosure. You authorize me as your broker to disclose information about the property to the agents, subagents, prospective buyers, and all inquiring parties. It shall be in accordance to the broker's company policy, which is to disclose any latent defects or material facts on the property. The owner authorizes anyone having a lien on the property, including a mortgage, to disclose complete information about the lien to the broker and closing attorney or the agent. So this, by the way, Mr. Seller says that at some point in time, you don't have to tell me if you're not comfortable telling me what you own the property, but at some point in time, you're going to have to tell someone, and it's either going to be me or the attorney, so they can just pay it off and disperse the funds. Taxes, paragraph 11. Basically, it says at closing that you'll comply with all taxes, and if any past property taxes are due on the property or any liens on the property from the government, they will be paid, and that taxes will be prorated at closing, and depending on the time of year, you will more than likely owe taxes to the buyer because the current year's taxes have not been paid. Now, we're about to get into a time of year. I don't know how it's going to be delayed with COVID as far as the tax bills going out, but as you start to get closings in the second, third, or excuse me, the November, December, January timeframe, if the taxes have already been paid, then the buyer will owe it to the seller for a very minimal amount. Coastal Tidelands and Wetland Acts. In the event the property is affected by the provisions of the Coastal Tidelands and Wetlands Act, you will have to have an addendum that's attached to this. This is going to be mainly properties that are going to be on the coast, right on the water. This is going to be pretty specific to properties, so we'll actually probably we'll cover that specific one on one of the 4th day of the month series as we get more into this, but this is going to be very specific to waterfront properties. Okay, paragraph 13. One everyone wants to hear about. So this is the multiple listing service, the MLS, and public marketing. The initial one option, not both, one. The first option says that the property will be entered into the multiple listing service of which the broker is a member, which would just by default would be Charleston Trident Association of multiple listing service. And it'll be the time frame stipulated by the rules and regulations. Okay, the timeline, just to be clear, the timeline stipulated by the rules and regulations of our MLS is within 1 business day of public marketing. It basically is going to default to what the NAR rule is. Okay, owner agrees that the broker may compensate an agent representing the buyer from the fee described in paragraph 3. Owner agrees or does not agree that the listing will be placed in the electronic marketing mediums, including but not limited to the internet, MLS, etc. So they're going to put that they agree to this. Now, if they've initialed option 1 and they've agreed for it to be in the MLS, which they will technically have to do because you're a member of the association and the MLS is owned by the association, they can initial this. You can sign the listing agreement for today, but it does not mean it has to go into the MLS. If you want to wait till October 1, you can wait till October 1. But what the rule states is that if you list it and then you want to go share it on the Charleston Realtors page, or if you want to go and put it out on the neighborhood Facebook page, then you've gone public and you now have 1 day to put it into the MLS. Now, the question then comes up is when I put it in the MLS, how long can it go without showings? They have waived the rule of saying you have to be able to allow showings within a certain period of time. So let's say you list the property today. Your intent is not for it to go on the market until September 15th. But then this afternoon, your seller goes and puts it out and says, hey, guess what? My house is coming on the market. Here it is. It's for sale. Contact my agent for any more information. That has now gone public. So you have to get it in the MLS. Now, you could put it in the MLS today and state in the MLS and then not allow showings until September 15th. The MLS is not going to require you to do that. They're going to ask questions, and don't get me wrong, you will get tons of emails and inquiries from agents saying, why can't I show it? Why can't I show it? But you still have the right to do that should you want to do so. Again, broker and owner agree to abide by the rules and regulations of the multiple listing service on which the property is listed. This is the same, by the way, for those of you, if you are going to be joining either, obviously CTAR and the MLS here is the default one. However, if you were a member of Beaufort or Columbia or Myrtle Beach, they have the same rules. Option 2 would be if they do not consent for their property to be put in the MLS and instead want to have their property listed as an exclusive brokerage listing. Very rarely are you going to have that happen because at that point you really cannot market to anybody except for, technically as it's written, it's the people within your Keller Williams office. It's not just Keller Williams Charleston, in which I'm a broker. It would specifically be to your office, which is silly. I'll just put it that way. So again, at the end of the day, the intention of this is good. It's still working out some kinks. Don't get bogged down on how much you don't like it or what the problems are with it. Just know that the MLS has done everything it can to protect us and that you don't have a timeline. It has to go into the MLS once you sign a listing agreement. And you don't have a timeline, as long as it's reasonable, that is when it goes live in the MLS that they have to allow showings. All right, so the question is, have come across some listings that are on Zillow but not in the MLS, is that permitted? So the only time you would probably come across that is if it, well, Regina, what's the situation where that came across? If it were a Kiowa property, it's probably because Kiowa Island Real Estate is not part of the MLS.
And what a joy they are.
However, if you put it on Zillow and you're a member of the MLS and the association and they've signed this agreement, then it would have to go into the MLS within 1 business day because you've now put it out to the public. If that did not answer your question, let me know. All right. Lockbox. The owner agrees or does not agree for MLS Lockbox to be on here. Now, if you have tenants in the property you will want to add, make a little note on this, you will want to add the lockbox addendum for them to sign as well. You do not need to have a lockbox addendum if it's an owner-occupied property, because this basically covers everything that the lockbox addendum covers. However, if you do have an investment property and you have tenants in there, it is in your best interest as well as mine for you to have them sign the lockbox addendum, which basically says people are going to be showing your property. They are going to be showing with an approved agent who's good standing with the board. However, don't leave your stuff laying around. And if something does get stolen, it's not my fault. It says it more eloquently than that. Owner understands that the broker's responsibility is to present offers to purchase to the owner for owner's consideration, terminates at the closing of the subject property or expiration of this agreement, whichever occurs first. So Mr. and Mrs. Seller, once this agreement is terminated, if there are other offers that come in, I don't have to present them to you. I don't know an occasion that would really happen unless obviously they sell the property, or if you've received offers and they've relisted with somebody else. If you've terminated the agreement, they still haven't relisted, you get an offer, I'd suggest submitting it to them if I were you. This one is confusing because it says marketing the property after accepted offers. The broker shall not continue marketing the property after the offer has been accepted unless requested in writing by the owner to do so. Technically, it's not offered as active. It will be offered as active contingent that's being in the MLS. What you don't want to misunderstand this paragraph to say is that the owner can request in writing that it'll be marketed as active, not active contingent. You have to mark it as active contingent in there regardless of what the owner wants you to do. That's the MLS rule. Paragraph 17 says commissions are negotiable. There's no control of commission rates or fees. Paragraph 18, they agree to maintain the property, including the lawn, shrubbery, etc., once they get a contract on the house between the day of getting the contract until closing. Agreement to sell, this is always a fun one. If you sign an agreement to sell, you will agree to sell. This is a binding agreement, and that you will cure any defects in the title, pay any subsequent taxes, any expenses that you have. Paragraph 20, in the event the home was built before 1978, you will sign the lead-based paint disclosure, which we'll cover on another one. We're going to cover more seller things probably in the next listing. Mediation, paragraph 21 basically says if you and I, seller and buyers, or seller and agent, disagree on anything, that we will mediate, agree to at least try to mediate before we'll sue each other. Okay. I've never seen this exercise in my time as a broker where there's a mediation that has had to happen between a listing agent and a seller. Typically because we've worked it out. I'm not going to say there ever has been a conflict, but typically we've been able to resolve those conflicts. Paragraph 22 says that you will not discriminate. I will not tolerate any discrimination whatsoever as your agent. And just need to be very clear on that. You'd be surprised that does, I haven't seen it in a while. However, yeah, I actually see it more. I've seen it more recently on the buyer's agency agreement, saying that, you know, we can't discriminate. And it's fascinating. It's not fascinating. It's disappointing. But this is a disclosure that you would have in there. Paragraph 23 says that you can use fax as communication. So I know, Weston, that's probably a common communication for you and
all the time, every day.
Right. Enforcement. This is an enforceable. This is an enforceable agreement, and that that I may take action to enforce the agreement and collect the associated costs should we have a closing. Seen this kind of tiptoed in. I've seen agents get sideways with their listing agent or their buyer, or either listing or buyer's agent. Seen them get sideways with that a little bit, where the client, you know, at the last minute says, you know what, I feel like the agent should pay me or discount or whatever. This says, no, that's not really how that works, right? And that this can be enforced to collecting the costs and any fees or damages should the seller default on the contract. Paragraph 25, again, this is a little overkill on the listing agent side, but it basically does say on the listing side, it does say it's not the broker's responsibility to obtain or disclose any information as it relates to sex offenders or criminal information in the area. They can obtain that information on their own, and they can disseminate it as they see fit, but it's not an obligation of the listing agent to do so. Paragraph 26 basically says the seller irrevocably conveys any and all of the seller's audio, photography, and videography rights in perpetuity involving the seller, seller's family, and seller's property to the broker for marketing and advertising and any other purposes deemed necessary for the broker. As you could tell, these last two have been edited and changed in the most recent update. Someone clearly has been sued, which is why this paragraph 26 and 27 has come about. Here's how I would explain it in a way where it's not telling your seller that you're going to be taking pictures of their family, as it says in here, and putting it out on the internet. It's simply, Mr. and Mrs. Seller, we are going to have a photographer coming out. My agreement with him is that we do own the rights to that photography. So this is just saying that when your home does close, this still will remain in the system. We still will have that, and that will remain the property of ours. We're not selling it to anyone else, but I do want you to know that it will be disseminated out and will remain on a lot of the websites with sold data, as well as either expired, under contract, whatever it may be. Use your judgment on how much you really want to get into this. Some sellers don't care. Some sellers, you'll know from the beginning whether or not they're going to care. But we have had situations where either they've withdrawn it, or once it's sold, they are absolutely adamant that we take down as many they can't believe that it's still out on Zillow. We just need to explain to them that there's a risk that it is still going to be out there, and the photography belongs to us unless they have their own, and then you can strike it. All right, so this paragraph 27, I always have to read it because it's from each perspective, it's interesting. So basically it says surveillance. Seller agrees to abide by any laws and regulations regulating audio and video surveillance of the property and persons entering the property, including agreeing not to use any surveillance in areas where persons have an expectation of privacy, such as restrooms. Seller agrees that broker may or may not disclose potential surveillance as broker deems necessary, including signage on the property and advertising marketing. So basically, this is what you're going to say is, in the event you have any sort of recording devices that need to apply by South Carolina law, do not get into the explanation of what you feel is right for everybody asks me this, well, what's allowed by law? That's not our expertise, right? We can't be surveilling. Now, it basically comes down to most audio surveilling is allowed in areas that are obviously without the expectation of privacy. Also want to understand, though, that Mr. Seller, if you do not allow me to disclose the potential surveillance on this, just know that the buyer's agent more than likely will disclose potential surveillance, because the buyer's agency agreement specifically has this same paragraph, but reversed, saying to beware that you may be surveilled when you're in the house. Again, this is a risk management thing. A couple things to take from this. Number one, if you're a buyer's agent, don't stand in the house and start talking about how much you love it, what you want to offer. Don't stand at the front door and do that. Just understand that this, people may listen to you. I have seen this work out actually in a positive way. We had, it was actually Lynn's aunt and uncle in Charlotte listed their house and had it on the market for a while and could not get feedback and could not understand why it wasn't selling. They put a recording device in the kitchen, and she literally spent all weekend downloading showing all the feedback, and went and changed everything, went and basically sold the house in a couple days after doing that. So it's not, it's not required on there. So the question is, it's not always a bad thing, I should say, sorry. So the question that Jen has is, are we just required to disclose cameras in the MLS listing? Again, it will depend on, I think the camera can only be done if it's not audio. And if you're only required to disclose it if the law says you have to, depending on where it is. But if as it says in here in surveillance, if the seller does not allow you to do so and it's compliant, it says you cannot disclose it and it's compliant with South Carolina law and under surveillance, then you don't have to disclose it in the MLS or anything. But just understand that it's probably not a great thing. In many occasions, disclosure is always good. It's find out now or find out later. So just something to keep in mind. All right, other conditions or terms. Really a couple things you could put in here is if you do have any variable rate commission, you would put that in here. And, in the event that the listing agent represents both buyer and seller, commission will be reduced to blank. If you are having any sort of deal where they, if they purchase with you, you could put that in here. This is also where you can put your easy exit agreement, because you've now gone to that default June 31st and June 30th and December 31st you can put that in here that they can terminate the agreement in writing. This bold paragraph here basically says what you're signing is a legally binding agreement. If you have any questions about it legally, contact your attorney. And that's it. That is the listing agreement. So what are some questions? What are some questions on the seller side, listing side that you have that we could cover today?
Joseph,
Yes.
back to the very first page. So I was driving in, podunk world that I live in, totally lost service. I have a listing coming in a neighborhood out here in Mott's Corner. We're probably not going to go on the market until like November 1st, let's say.
Okay.
But I want to go ahead and get that bad boy signed.
Yeah.
What dates am I putting? I'm so sorry to make it complicated, but it confuses the heck out of me as to what dates I'm putting where in that listing agreement.
So let me pull this back up because you're not alone. So if you want it signed now, you can put right here, you can put September 8th.
Okay. But it's not
Because
going in the
now-
MLS today.
Correct. This is not coincide with when it goes in the MLS, because when you put it in the MLS, the entry field in the MLS is now changed from listing date to date of MLS entry.
So this date on this document will not match my entry date on the MLS
Correct.
if in this particular case.
Correct.
Okay. All right. And so we don't have to, okay. I'm still got my North Carolina contract in my head, and that's where I'm confusing
Yeah.
that and the within 2 days thing that we have with MLS now.
Well, we don't. It's
The
not
well,
like-
the one day thingy, whatever that is.
Mhm. So now,
Am I
if
making
you sign this and you date it today, and they're not going to put it in until October 1 or whatever it may be, or November 1. If you go public with it at any point in time between those, then you technically have to put it in the MLS at that point.
Right. But when I go, so if they sign it today,
Mhm.
and so that date will be on this page 1, but we're not putting in until November 1st. When I enter it to go active, I'm putting November 1st in the MLS.
Yes.
Correct? Okay.
Yes, because
Perfect.
the field in the
All
MLS is now date of MLS entry, not listing date.
Not listing date. I gotcha. Okay. All right. Hopefully
Yeah.
I'll remember that. Thank you so
Yeah,
much.
there was, absolutely. And, the MLS did do a lot to help us not get around, but help us still do business with this clear cooperation rule. I think there's some other things that can be added, a coming soon module, that sort of thing, blah, blah, blah. However, for the most part, these two changes where you can have whatever date on here, and then you can have listing entry date. And by the way, you can also put it in the MLS, but not have it shown for a week or two. The only challenge with that third option is then you have days on market that are higher. That's, honestly, at the end of the day, that's for stats purposes, and don't die on that hill. If it's an extra 7 days on there, then just do your own stats and take those 7 days out if you want. So good question though. Anything else?
Oh, go ahead.
Go ahead.
I have something on paragraph 19, Joseph. I don't remember. I just literally wrote paragraph 19.
Paragraph 19. Okay.
Okay. So with that, how far is that enforceable? What are the things as far as when a buyer is found for the property, I guess I'm just trying to find the bounds of that one.
Yeah, it's pretty vague. And because this is what happens is you've got, say for example purposes, you list a house at 300,000 and somebody comes in, they have an all cash, 300,000, no contingencies as is, closing in 2 weeks. One could argue that that's an agreement they should agree to sell that. And by not agreeing to it, this paragraph would technically protect you so that you could say, it falls under this here, right? It's a written sales agreement, terms and conditions of the sale. It's fairly customary as to what it needs. So that would be an agreement to sell. That's what an agreement to sell is. So this is really more protection from you as the agent standpoint, to just not leave it willy-nilly that it only comes down to a ratified contract.
Okay.
Now, where I have seen situations where there's been a contest on commission because the seller didn't cooperate, rarely is it if a seller just randomly changed their mind. and then and they haven't taken any fault for it. It's normally happens either after. Well, we currently have one right now that we're dealing with where they're under contract and the sellers change their minds, completely change their mind, and doesn't want to sell. And there's bigger issues, quite honestly, for that seller than whether or not they owe the listing agent commission. They've got a contract to sell their property.
Yeah.
This is as it relates to you and them and the listing commission. This is
Okay.
really prior to getting that agreement. However, it protects you even more should they have an agreement to sell.
Okay.
So in the example I just gave you, this would really protect our agent to say, hey, you had an agreement, you signed on the agreement to sell, and you backed out on it. You owe me that commission. I'll tell you 9 times out of 10, there's a reason that's bigger than the commission that's happening.
Right.
And most of the time, a seller's either going to be in a position where they're just, I mean, we had another one a few months ago. It was they got a job, they lost their job and got a new job in Florida, and then COVID caused that new job to go away. And they were like, why would we sell? Like, we know we have our house here. Why would we sell? They were under contract. I mean, it was, and if you got to put yourself in the buyer's shoes, you want to tell the buyer, well, come on, he lost his job. Well, the buyer's like, hey, I had a house to buy. So there's a lot more conflict. And again, I don't want to say we always roll over on the commission, because that's not really the case. But a lot of times it's going to be a bigger situation than that.
Right. Yeah. It's, in the end, it's not just about the commission.
Right. But you're also not going to be out there, working for free.
Exactly. Yeah.
Okay.
Cool. Thank you.
Yep. All right. I think there's another question. Who else had a question?
Okay, so my understanding is that once I put a listing into MLS, I have to make the showings available within 7 days.
No, there is no time limit on when the showings are available.
Okay, good, because I put it in the MLS, but we come to find out we need to do some painting and carpet cleaning before I want to start showings.
Yep.
So I was trying to hold off on that, and I found out she won't be able to get that done until like Friday. Okay.
Yeah,
I just
you'll
want to
be
make sure I didn't.
fine. Yeah, it'll be you'll get a lot of calls. Like that's a separate situation. That's kind of one where it's like, hey, you're talking about a few days. If you've got one where it's going to be a week or so out, you'll still get calls. I mean, this is, and here's what I'm going to encourage you to do, by the way, is if you've got challenges with these, and this isn't it, John Drea, like this is a question everyone has. If you've got a challenge with this and you don't like how this is, come to me and let's go through the proper channels. Let's not get involved on the Facebook, like the Charleston area, like on how stupid the rule is. And by the way, I'm guilty of saying that here in these groups. I don't particularly love how this rule's turned out. That being said, it is a rule now, so let's be professional about it and make sure if we do have any issues with it, that we handle it. And John Drea, that was not directed towards you. It just, you brought that up, and that particular, your situation is totally perfect. And I could see that one being a complete defense as to why this rule kind of makes it a little challenging for us.
Yeah. Okay.
Yeah. All right. Anything else? All right. Let me make sure. All right. Well, if no more questions, we're out in an hour. If you have anything or need anything from me, let me know. Just give me a call or shoot me an email.
All right.
Awesome.
Thank you.
All right. Bye, guys.
Joseph.